1:30, and this is the July 11th Board of Adjustment meeting where we hear special exemptions, variances, oil and gas related cases, and appeals from other directors. I will call the meeting to order, and our first item is to receive the minutes of the June 20th meeting.
So moved.
Second.
All in favor? Our next item is continuances, withdrawals, requests by staff.
We have several today. Item number 1, case number 13653, 13655, and 13656 is asking for a continuance to September 5th. Item number 2, case number 13654 is requesting a continuance to September 5th. Item number 10, case number 13755 is requesting a continuance to August 1st. Item number 11, case number 13757 is requesting a continuance to September 5th. And item number 15, case number 13756 is requesting a continuance to August 1st.
Motion for approval? We've got this continuance by staff, then we'll have continuances by the public.
Okay.
Kathy read number 11.
Yeah.
Question is, do we have one that's objected to?
Yes, we do have two objections. I'm sorry. On agenda item number 11, there are two protesters. So, Mr. Humphreys?
Mr. Chairman, before we begin our deliberations, I'd like to recuse myself.
Okay.
Mr. Chairman, members of the board, my name is Kirk Humphreys, 333 Northeast 4th. I'm the manager of the company that owns the former downtown Air Park site immediately across the street from the applicant's property on item number 11. This item went to the Riverfront Design Committee last week and was recommended by staff for approval. It was denied by the board unanimously. We protested it, and it was denied by the board unanimously. It's on your agenda today, and we've owned downtown Air Park for 7 years. We want to move forward with development, residential and limited retail development. The outcome of this case significantly affects our ability to finance a project such as that, to attract an apartment developer, to successfully get renters and owners to move into that property. A 3-month delay has very real consequences. We didn't ask for this timing. Apparently the applicant did. We're ready to go. And you know, that they say, I'm not a lawyer, but they say when the facts are on your side, argue the facts, and when the law is on your side, argue the law. When neither the facts nor the law is on your side, ask for a deferral. We're ready to go today. It has significant importance to our city, not only to downtown Air Park, but to Court Shore. And we would ask for the item to be heard today. We see that none of the facts are going to change in the next 3 months. We would ask you to hear this item.
Okay, thank you. Also is Mr. Reynolds.
I think he is here as a supporter of the applicant. So I don't know if Mike's wanting to speak or not, but if I could.
Go ahead.
Dennis Box, I'm here on behalf of the applicant. And one of the things that I think is important, the hearing that Mr. Humphreys talked about took place on the 5th of July. At that hearing, as Mr. Humphreys indicated, the staff recommended approval of our application. The design group determined that they didn't think they had jurisdiction and didn't feel comfortable in overriding the ordinance, and as a result, never even looked at design characteristics. So when we look at the facts, when we look at the law, we believe, since we have filed an appeal from the design group, both items should be heard at the same time. And if you hear both items, you'll see what the design group did not look at. Then you'll be able to hear both the facts and law, which, contrary to Mr. Humphreys, we believe that the facts are on our side, and We believe the law is too. This is a scenario, and the handout I gave you, if Mr. Allen will remember, I actually appeared at this pre-meeting for the Planning Commission with my clients at this date, which is April 12, 2012, to make sure that there was an assurance from the Planning Commission that we would be able to proceed, even though the ordinance was being amended, to follow through with our development plans, and we were assured that that would be a possibility. Paul Lefevre coordinated with the city staff. That's how this ended up at the Board of Adjustment and not the Planning Commission. But with regard to the Board of Adjustment, I think it's important to note, and the last 2 pages that you all have in front of you, those are cases that I have followed through both at the Design Review Group, the Planning Commission, and the City Council, where with a broad stroke, the city came in and implemented the river ordinance, and 2 of those properties were vacant. One of them had a warehouse on it, and the city came back through a PUD mechanism and allowed for the industrial to be put back on the property, and for our client to go ahead and develop the vacant properties and allowed them to have adequate insurance on the existing buildings. So what we're asking for is not out of the norm. When you hear the merits, I think you'll understand that we want to be a good neighbor. And in fact, Mr. Humphreys has gone and placed a PUD which allows for temporary use up to 3 years for a music venue. My client didn't object. My client is excited that Mr. Humphreys and his group are going to do development in the future. We think our development will be compatible. So long and short of it is, we think you ought to hear this just once and hear all the merits and also the appeal from the design group. But we're here to answer any questions if you have any.
Questions for Mr. Box from the board?
The staff report. On July 5th, the committee recommended denial of the requested variance, finding that the request was inconsistent with the ordinance and would set a bad precedent. Can you elaborate on that, explain that?
I didn't watch the hearing. That comes directly from their minutes of their meeting.
Okay. Can you...
I can respond by saying that at least one of the members raised their right hand and said, I was sworn in to uphold this ordinance, and I'm not going to do anything that would be contrary to it, keeping in mind the cases I showed you, are,
I guess I'm not completely clear on it. What I understand is that this Riverfront Design Committee is designed to create some uniformity in the process. They took a look at this and they said that it's inconsistent with the ordinance and it would set a bad precedent. And so I find that problematic and troublesome. And I don't understand the explanation that you've given so far as to why it is not inconsistent with the ordinance and why it would not set bad precedent. And with a 3-month delay, if we're going to end up at the same spot because it's inconsistent with the ordinance and it's bad precedent, I don't get it.
We can explain the merits if you want me to, and we're not opposed to a 1-month continuance if Mr. Chambliss can get the appeal, which we are filing from the design group, before you. We're not trying to delay for delay purposes. We just think we ought to have a hearing. And I think some of the questions you have when you read the transcript will become clear. They never looked at design. They just took a position that if the ordinance didn't allow it, then they couldn't modify it. Well, Mr. Humphreys has had a PUD that's gone through them. I've had 3, and so they, on a routine basis, look at cases where you can vary the riverfront ordinance, and have.
I would I would suggest this. You are wanting to ask for a 1-month continuance now. You've gone from 3 months to 1 month. Why don't we put this on the regular docket, let them have a chance to visit, and then we'll take it back up on our regular docket. Is that okay?
There's a motion for the continuance.
For all of them, so you would have to you'd have to modify the motion and withdraw number 11, and then bring it back up on the regular docket. Is that the motion you're making, Mark?
The motion I'm making is that we do not continue at this time. We give the parties a chance to speak, as we've always done in the past, see if they can come up with some agreement. If not, we'll hear it on our regular docket as item number 11.
Just
That's my
strike
motion.
number 11 from the continuances.
Okay, so we'll strike number 11 from the continuances,
Yeah.
and then we'll vote on the continuances for the other 4.
So you want us to go talk between now and the August hearing?
No, between now and item number 11 on this docket today. Okay?
We'll talk.
Mr. Reynolds, you also wanted to say something?
Yes, thank you. My name's Mike Reynolds. I'm state representative. I'm here to see what statutes we may need to modify at the state in order to make sure a situation like this doesn't perpetuate. I was shocked to see a protest by someone that claims they're for the economic development of Oklahoma City, and just a few moments ago acted like they spoke for the city, get up and say, helping a company that's been in a location for 59 years is not good for the economy of Oklahoma City, but helping me, who've owned a piece of vacant land for 7 years, is good for the city. That's astounding. And then I hear one of the members say, gee, why don't y'all go out in the hall and discuss this? That makes absolutely no sense to me. I cannot understand why a continuance wouldn't be agreed to. That makes no sense. I'm familiar with a piece of property called the Flatiron. And Mr. Humphreys, or one of his companies, purchased that probably 9 years ago. Made news because they had to do a quiet title or something that to remove a deed restriction. They're allowed to serve alcohol. And then the city granted TIF money. And that property is set empty for 9 years. So I'm concerned that Mr. Humphreys cannot deliver while Evans Electric has been delivering consistently for 59 years, and I'm shocked that this board would not grant a simple continuance. I'd be happy to answer any questions.
Any questions from the board? Okay, thank you. We have a motion. Do we have a second?
The motion is to continue the 4. Let me make sure I know what I'm voting.
Correct. We're continuing the 4.
Okay, second.
All in favor?
Yeah. I vote yes.
Okay. In the interest of time, I know we have 4 cases that have to do with the events that happened surrounding the May tornadoes, and those people have taken away from work and are mainly representing themselves pro se. So we're going to go ahead and move those to the front of the docket. They should go very quickly. Kathy, will you call the first case?
Sure. Item number 8, case number 13752, request of Darren and Jaylan Jan for a variance to allow a recreational vehicle as a temporary dwelling during construction of a permanent residence located at 1311 Southwest 149th. Item number 9, case number 13754, is a request by Wayne and Patricia Osmuth. Their property is located at 1313 Southwest 149th. Item number 13 is case number 13760, request of Alan Harnett. His property is located at 1205 Southwest 149th Street. And item number 14, case number 13761, request of Rhonda Northcutt, and her property is located at 15900 South St. Clair Avenue.
Dan, can I move all 4 of them, or do you need separate?
Take them one at a time.
Okay, if there are no protests. Okay, I'll move item 8, move approved. Second.
All in favor?
I'll move item 9.
Second.
All in favor?
Number 13, move approval. Second.
All in favor?
And I'll move approval number 13.
Second.
14. Sorry, I meant number 14.
All those in favor? Thank you, guys,
Okay.
for your time. Those items are approved. We appreciate you taking time from your schedule. Sorry that you had to come down here, and hope that your process goes as smoothly as possible. Thank you.
Item number 3, case number 13753, request for use variance of Barron Exploration Company for permit to drill an oil gas well located at 7400 West Wilshire Boulevard.
Mr. Chairman, I need to disclose that I own a farm in Logan County that Barron has two oil wells on. And if they have a problem with me sitting on the board while this is going on, I will remove myself. If not, then I'll stay.
We have no problem.
Thank you.
That's fine with me, Mr. Counselor, so you're free to stay. Name and address, please, for the record.
Okay, my name is Jack Dake. Address is 2116 Cadwell Avenue in Oklahoma City. I'm land manager and operation manager for Barron Exploration Company, your applicant. This application pertains to an existing oil and gas well site at the north end of the Wiley Post Airport. It's a continuation of our development efforts. The access to the site will be through the existing oil and gas road across the existing oil and gas well site that has 3 approved well bores drilled and 1 approved well bore not yet drilled. This is what we call the south extension of that site, and is necessary because the topography in the north part of the existing site is not sufficient to support the drilling of this type of a well, which would be a horizontal well. The Wiley Post Airport, ALOS, Oklahoma City, owns roughly half the mineral rights and will receive half of the royalty benefits of this well, which we hope will be substantial. Everything has been approved by the Airport Board and Trust and the Airport Board staff, and believe that the approval of this would be in conformance and in continuance with previous actions of the board.
Any questions of the board?
Any opposition here today? Seeing none, I move for approval.
Second.
All those in favor? Thank you, sir.
Thank you.
Item number 4, case number 13742, request of Tom and Catherine Vaught for a variance to permit a porch encroaching into the front yard setback located at 6400 South Shore Drive.
Hi, I'm Tom Vaught, owner of the 6400 South Shore. We recently purchased this property and come to find out, applying for a building permit, that the garage is located in an area that is no longer permitted to build in. We wanted to somehow establish that could be accepted, and because it's existing. It's been there 51 years, I guess. And the actual building permit that we applied for, the overhang would be 2 feet over the limit. So we're just asking for a 2-foot variance on that.
When I read this application, I was confused about whether we're hearing a variance request regarding the garage or a variance request regarding the porch, or both.
The garage is existing. We were told that it wasn't acknowledged, that it was okay to be there, is what my understanding is.
I think
And the only variance we're asking for is the 2-foot overhang.
Yeah. It's a setback requirement. Are any of your neighbors any protests of this?
No, not that I know of, no.
I'd make a motion to approve.
Second. All those in favor? None opposed. Thank you, sir. You're approved.
Thank you.
Item number 5, case number 13749, request of Coyle Mashburn Development for a variance to the 20-foot platted front building line and minimum 40-foot lot width located at 12021 Sawgrass Road.
Good afternoon. I'm Kendall Dillon with Craft and Toll, 214 East Main. I also have the applicant, Mr. Carter Forey, with me today in case you have any questions of him. This application pertains to 21 vacant lots that are inside of the Glenhurst Section 6 subdivision, which is a private gated community. And these lots are currently platted with a 20-foot front setback, and we're here today to request that we be able to utilize a 15-foot front setback. So if you'll notice on your map in the staff report, you'll notice that all of these lots are located on and around eyebrows and cul-de-sacs. And the interesting thing about this piece of property is that the current PUD, the zoning, currently permits a 10-foot front setback, and all of the lots that you see on that map that are on the straight or the tangent portions of the street are platted with 10-foot front setbacks. So the issue that we're having is that on these cul-de-sac and eyebrow lots, if you look, the lot depth is already reduced, and you add the additional 20-foot or the additional front setback, and then you combine that with some other conditions that we've got in regards to steep grades in the backyard. There's actually a 30-foot utility easement on the south and a 25-foot on the northeast and the rear. So you add all those factors together, and we're struggling to be able to build houses that are consistent and compatible with the existing homes that are there. So that's the reason of our application. As far as having any impact on the other properties or adjacent, obviously all of our lots still have a greater setback than the existing ones. They're along curves, so there's no visual impact. You'll not be able to notice it. And then again, we're asking that instead of going from a 20 to a 10, we're just asking that it be reduced to a 15 front setback. So we feel like it's only 5 feet, but we really feel like that'll make a big impact on what we're trying to do and accomplish. So there are no unfavorable considerations, so we'd ask for your approval.
You had nobody protest this in the neighborhood or anything?
Not that we're aware of.
Is there anybody here in protest or opposition? Questions from the board?
I'd make a motion to approve based upon the grading and the fact that the lots sit on cul-de-sacs.
Second.
All in favor? Thank you, sir. You're approved.
Item number 6, case number 13750, request of Philip Fitzgerald for a variance to allow a freestanding accessory sign exceeding the maximum height and size limit located at 14440 North Pennsylvania Avenue.
Mr. Chairman, I'd like to recuse myself from this case.
Thank you.
I'm Philip Fitzgerald, the architect for Dental Depot, representing them. We're asking for a variance. The project is in a PUD, and that particular PUD did not allow signage on the front lot. And we're asking for a variance to allow signs to put on their water tower, similar to all their other projects around town. And we've got photographs of other signs up and down the street that are consistent with what they're doing. So if you need to see those, we've got some photographs if they haven't been a part of your packet.
Questions from the board?
Anyone here in opposition today? Are you aware of anybody protesting?
No, sir.
Make one comment. I think the city made a comment that the sign footing must maintain a minimum 10-foot separation from public water mains and sanitary sewer, and that's been taken into consideration in your application. Okay.
I'd move to approve.
Second.
All those in favor? Thank you, sir.
Item number 7, case number 13751, request of Stephen and Carrie Fisbeck for a variance to permit a detached accessory building encroaching the 25-foot side yard setback located at 2000 Reveille Road.
Yeah, I'm Steve Fisbeck. I'm the property owner that has asked for this variance. And Steve Meeks, he is the one that will actually be putting the building up for us.
Steve Meek at 9021 Northwest 147th Place, Oklahoma City. I'm with Morton Buildings. Just have a couple of brief comments. I think staff probably gave you some computer-aided depictions of what the building would look like. This is a nice treed area. In fact, Mr. Fisbeck has some Google Map overhead views. Greenbelt area, large lots. There's a couple of items just to mention briefly. First of all, the area that's immediately southeast of the house slopes dramatically to the east and to the south, would be quite problematic as far as vehicle access to an accessory building. Then if you looked at the site plan, we'll let Kathy pull that up. Thank you, Kathy. Oh, I guess Kathy wasn't doing that. Sorry, Kathy. The site plan, if you have a copy of that, it shows where the proposed structure is going to be, and the south edge of that proposed structure from there towards the house that sits immediately south of the owner's property. That is almost like a park setting. It's very heavily treed, canopied area. And so to move the building further south, it does tear down from the proposed location. And to move that building further south would probably be, I would think, from the south property owner, adjoining property, would be a little bit more of, an issue in their minds. There was a couple of things that I noticed in the staff report that we just wanted to draw attention to. One of them is, if you are able to look at that site, it shows, or the site plan, the property immediately to the west, it looks like that there's a house that is very close to the Mr. Fisbeck's property on the west side. That is actually an accessory building. The house that adjoins them to the west is quite a ways south, about 200 feet. So there's not a residence that is close to that west line. Obviously, this is an accessory building that was, looking at the age of it, is obviously grandfathered in. The garage on the current home is at the west end of the house, so obviously the accessory building being to the west side of the property makes a lot more sense. But now if we meet the 25-foot setback, it virtually puts the accessory building right in the middle of their immediate backyard. So that's the reason for the application to have it closer to the side yard.
Now, I've spoken to all the neighbors that have adjoining property. Nobody protests, nobody has a problem. And I had a neighbor, about half a mile away. He stopped by this past weekend, wanted to know if I needed a letter of support, and I told him I thought we were okay because we hadn't had any protests from any of the neighbors. We are in the process of adding on to our house right now. We've got an architect that is drawing that up and supervising it. Before I signed off on this building that I'm talking to Steve about, I had the architect sign off on the building and where we were planning on putting it, because I do not want to take away from what the architect is doing. But then again, if the building's right in the middle of the backyard, right off our back porch, it kind of defeats the purpose of having an architect and doing the addition to the house.
Do you have a septic system or something that you can't move that on further to the east?
We had to replace our septic system. There were lateral lines where the building, in the proximity of where the building that we're trying to put it now. When I tried to replace my lateral lines, I went in with an aerobic system.
Okay, so is your aerobic system within that area that you couldn't move it to the
Our aerobic
east?
system would be kindly on the southeast of our house. And right there where the aerobic system is, then there's like a 8 or 10 foot slope before it levels back out and runs off towards a creek.
So if you move this to meet the 25-foot side yard setback, you're still not going to be in the system, your aerobic system.
Oh, no.
So why can't you move it to the east and stay with the 25-foot setback?
From the proposed location, move it to the east, I'd have to move it roughly 200 foot to the east. The topography of the lot is what has got us.
Are you asking why it couldn't be moved east from the proposed location or moved to the east side of the house?
Move it east from the proposed location.
Well, as I stated initially, that would actually put it right in the middle of their immediate backyard of the house. You know, I try to look at all of these locations as, if this were my property, what would I want? You know, and as an accessory building, even though we're proposing a structure that is attractive, I don't think anybody would prefer to have this accessory building sitting right in the middle of their backyard whenever it could be off to the side. That's the
reason for the 25-foot setback is for fire. Okay? And if somebody builds on the lot to the west of you, and even a house, and they've only got a 25, we're supposed to have a 50-foot separation between structures. Would you be willing to put a 2-hour wall on the west side of your building?
There's already an accessory building for the west property owner that is actually within 5 feet of Mr. Fitzpatrick's property.
That makes it even worse then.
But the point is, they're not going to build another house. There's already an existing house on the west property, which is probably 200-some feet southwest of the proposed structure.
I would not be willing to vote for this unless you would be willing to put a 2-hour wall on that west side. That's the reason for the ordinance.
It's 2 sheetrock, fire code sheetrock.
That'd be agreeable to you both?
Yeah, I can do that.
Then I would make a motion to approve that.
Motion to approve subject to a 2-hour firewall on the west side.
Second. Yeah, I can go.
All those in favor? And opposed? Thank you, sir. You're approved.
Item number 11, case number 13757, request of Evans Enterprises for a variance to allow the expansion of a non-conforming use, the prohibition of sheet metal siding, the 30-foot maximum height limit, the 30-foot maximum front yard setback, the required number of parking spaces, and the screening and landscaping requirements located at 1536 Southwestern Avenue.
Mr. Boggs?
Mr. Chairman, I'd like to recuse myself.
Okay.
Mr. Chairman and Ms. Stonecipher, we did go out and talk. We agreed to disagree. We would be agreeable to the 1-month continuance, and the reason is probably, as stated as well by Ms. Stonecipher, is anything, and that is conclusions about the design review group that I think are inconsistent with what I saw. Mr. Humphreys and I disagree on maybe what the board did, but we think you need to have all the evidence in front of you. That'd be fair.
And my position is it's on the agenda. I didn't ask for the timing. Other people did. I've canceled trips to be here. I don't think the facts are going to change, and I'd like the board to hear it.
Questions from the board?
Let's hear it.
So you're saying no 1-month continuance, you won't support it, you want to hear it?
I would support a continuance.
Okay.
But it's pretty obvious that Mr. Humphreys is in a kind of a bind. Is that what I'm gathering? And this thing has been on the board for...
To say we're in a bind would not be accurate, but the facts are that our group has about $10 million invested here. We've sat on it for almost 7 years through a bad economy, through moving the highway. The time is right, the economy's right to move forward. I have apartment developers that are talking to me that want to start construction. And, a month's delay is a month of interest on $10 million that has very real consequences. And I don't believe any of the facts are going to change on this, and I just as soon hear it. So, put us in a bind, no, but every day costs money on a development project.
Any other comments? I just want to say something. I kind of think that I don't know what's going to come out of the process. There may be nothing that comes out, but I understand it's very sympathetic to your business purpose. I mean, we've all done projects, we've run into that, but I just not knowing, if nothing could come out, nothing could change. But I'm a little concerned about not knowing what could come out of there and then I'll yield to my colleagues with any other questions.
That's my same concern, and I don't know what they're going to, this thing has been on the table forever, and, they haven't accomplished anything up to this point. What are they going to accomplish in another 30 days?
I don't think we will accomplish anything in regard to resolving any of the concerns that Mr. Humphreys has, but what it will accomplish is you all will have both appeals in front of you, and you'll have all the set of facts. And so, like Mr. Stonecipher's question about why the board did something, you'll have the transcript to read, and then we can paint the whole picture. The timing, we just filed applications, and it just ended up on docket. So we are sympathetic to Mr. Humphreys and his timing. The other side of it is we are wanting to push forward as quickly as possible. We just think for you all to have all the facts in front of you.
So you're saying we don't have all the facts?
No, because we've appealed from the decision that the design review group made, and that will come before you all. And if Mr. Chambliss is agreeable to put that on the August docket, then you'll have everything and you can make your decisions.
You can't be noticed.
It's only 20. What day is the August hearing, Ms. Chambliss?
August 1st.
Notices go out tomorrow.
Yeah, we'll mail notices for that hearing tomorrow.
That'd be okay with us. We'll
Give us what else is there to be brought to the board?
Okay, today, you all are going to be dealing with variances, which we are hopeful that you will allow us to be a business that can get contracts with Toshiba and continue to operate like they have for the last 59 years. And that includes, when you deal with the Riverfront District, you have two options. You can either go rezone it to a PUD, or you can come to this board and ask for a variance. The design review, as part of this process, reviews all the designs of any project that is brought before them. So today, if you voted one way or the other, you'd still have, hopefully in August, another hearing to deal with design review. Well, that would become moot if you all didn't support our variances. So we think they're intertwined, and all the matters should be heard at one time.
Were the issues on the design review heard on the 5th, or I'm unclear on when that was heard?
They were day after the 4th, and it's unfortunate. I mean, you file an application and it just comes up when it comes up. We didn't try to ruin anybody's 4th of July. In fact, I found it real unfortunate, but I was here. Mr. Humphreys was here too.
Yeah, Mr. Humphreys.
The Design Review Committee, I may be wrong, and perhaps Mr. Brumma could help us. My understanding is that they are a reviewing body and a recommending body. The ultimate decision is with this body. Is that correct?
Not with respect to the certificate of appropriateness. They make this, that's a final decision, but then it's appealed. It can be appealed to this body.
Okay. So they've turned it down. For Evans to do what they want to do, they have to get a positive reading from the Design Review Committee. It was denied 7-0. And they have to get a positive reading from this committee.
Yes.
It's going to wind up here anyway. The facts aren't going to change. We're just going to run, I'll tell you what, time has real consequences in interest and in business risk. And if there's a good reason to do that, that's fine. But I don't see any of these facts changing in 30 days or 90 days. I would ask you to hear it today.
Any other questions?
No motion pending for continuance right now. Okay. Well, let's go ahead and hear it since that's where we are.
ahead, Mr. Okay, next item on the agenda.
Wait a minute. We're hearing it now, is what he's saying.
That's what I mean. Yeah.
What other questions does?
I guess, David, do you want to put on some presentation? Because it's going to be heard at this time.
That's right. Mr. Lefevre, who made the presentation for the design review, he is going to make a presentation to you all, and then Mr. Humphreys, of course, have the opportunity to respond, and you all have questions, and if you have questions of me, I'll be here too.
Paul Lefevre, represent the applicant Evans Enterprises, Inc. If I may, it's my understanding that what we're discussing at the present time are the variance request as opposed to an appeal from the decision of the Design Review Committee.
That's correct.
Thank you very much. Evans is located at 1536 Southwestern. It's been there since 1954. It's located on property zoned I-2 and I-3. They do have property east of the industrial site that they own that's zoned R1, but that is not any part of this application from a use standpoint. Their use is moderate industrial. Because of the overlay of the Scenic River Design District, they are properly considered a non-conforming legal use. Because of the overlay, they are not allowed to expand, and that is the first reason why we're here, is simply to allow and change in the facilities in order to keep up with modern business conditions. Now, with us today is the Senior Vice President of Evans Enterprises, and he would like to speak with you very briefly, and then I'll finish up with our presentation if that's acceptable.
That's fine.
It's not a long list. I appreciate the opportunity. My name is Rusty Thrash. I am Senior Vice President, grew up in South Oklahoma City, 1336 Williams Drive. I'm a Grant General and have been in South Oklahoma City a long, long time. This is a family business. We have 315 employees, been in business since 1958. Mr. Evans built the first building here in 1958. We've actually started in 1954. We need the additional buildings. We're not changing the use of the buildings. We need the additional buildings for warehouse space and for manufacturing space. We want to be good neighbors. I know the area like I know the back of my hand. We want to put up trees. We want to put up fences. We want to be as conforming as an industrial business possibly can, long before that property was sold across the street from us to become residential. We service Devon, Chesapeake, Sandridge. The warehouse we're going to build is going to hold motors that will be invaluable to them for the pipeline. High horsepower, 2,000, 3,000 horsepower motors. We've got a long legacy here. Last 10 years, we've paid about $3 million in sales tax just from this location. Industrially, we employ about 150 employees. So look at us from the standpoint of we want to improve the area. We want to plant trees, both sides. We're not changing the use of the property. We're not adding height to any building. Thank you.
Now, Evans operates in a very competitive regional marketplace. They have recently been awarded a contract from Toshiba International. The contract requires that they have additional warehouse space available. This is a contract that was won over competition from Fort Worth and Lubbock, Texas. This is a very positive development here. The site, I don't know if you're all acquainted with it, but this is a view of the facility from the running path on the north side of the river, facing the site, and their facilities run along here east to west. Now, the proposed expansion is as follows. In red are the existing structures that you see on the photograph here. The Toshiba warehouse is here, and they're increasing the size of their motor repair facility here. Now, the proposed warehouse has a ridge height lower than much of the buildings to the north. And so from that standpoint, will be essentially invisible from across the river or at Wheeler Park. Sales at Evans in the last 2 years have increased from $18 million on an annual basis to $32 million last year. Hence, the need for additional repair space. This existing structure that fronts upon Western is their repair facility, and the ridge height of the additional area is lower than the existing structure. While we have this up, I'd also demonstrate here, we'll talk about the criteria and the specific variances in a moment, but right now we're proposing landscaping all along the eastern boundary of the property. To the extent that Oklahoma City would agree to it, you can see we have very little property boundary north of the existing buildings to do any landscaping. But to the extent Oklahoma City would agree to it, Evans will commit to also putting trees in all along the northern boundary, however the city wants that done. Similarly, Chesapeake owns the property to the south, and we can commit to approach them, and if they're willing, we'll put trees along the southern boundary also. I'd like to hand out, if I may, yes, this little site plan, I think, characterizes what we're trying to do from the standpoint that I've highlighted the areas of the site that are currently zoned I-2, I-3, and R1. You'll notice that all the existing buildings are within the I-2 and I-3 area. All the proposed buildings are also tucked away inside the I-2 and I-3 space. This is purposefully being done to minimize or eliminate any impact on surrounding property. we are purposefully avoiding expanding to the east into the R1 property, which would, we believe, perhaps be inappropriate from a increased impact on the neighborhood and the river. So many of our variances that we're going to talk about here are driven by our very tight footprint, the envelope that we're trying to construct these buildings in order to minimize impact. So though it seems like there's a number of variances, I think the common theme to all of them is that we're working with an existing site that has been here, facilities for over 50 years, and we're trying to do the most positive development we can given our needs. Now, we do recognize that the scenic river overlay imposes a restriction on the expansion of industrial uses. I would also observe, however, that we have a whole series of other mechanisms to amend or change those very broad brush rules, and this body is one of those. Planning Commission and City Council with a zoning change would be another one. Staff encouraged us to go this route, and we're in agreement that if we adjust the specific variances to this site, we are making the minimum number of changes required. Now, the variances are as follows. First of all, we're seeking to expand a non-conforming use. Now, businesses do not remain static. Business conditions change. I think an excellent example of this is what has happened to Mayor Humphreys west of this site, is that the economy has been difficult for a number of years here in Oklahoma City and nationwide, and that has limited development opportunities. He's had an opportunity to put his property to a productive use as a concert venue. That's all very understandable. That's perhaps not what was anticipated by the ordinance, but it is representative of accommodations that have been made to allow productive use of property. Similarly, Mr. Box has noted about WW Steel and other sites that he's gone to the Planning Commission and City Council and had adjustments made. So it's not correct that this ordinance is intended to be unchangeable. In addition, I would submit it cannot be the intent of this ordinance to cause very vibrant existing businesses to stagnate and not meet market opportunities. We have a wonderful opportunity here with the Toshiba contract. That's something that many cities have been hoping to get. It's here now. There are over 90 employees at this location whose average salary is $57,000. They are highly skilled blue-collar laborers. This is not just fixing mufflers or something like that. This is very highly technical work, and this location has been very viable for years. as I mentioned earlier, their expansion in sales from $18 million 2 years ago to $32 last year demonstrates that the market changes. And I think not to allow them to remain competitive and to respond to market changes, surely that's not what the intent of the ordinance was to do, was to shut down growth of many fine businesses along the river. One of the variance requests has to do with the metal construction. All of the existing buildings are metal. As I've discussed earlier, we're tucking these buildings away. This will be lower than the buildings to the north. This will be lower than the repair facility to the west. And it is an industrial facility, and the metal structures are appropriate. They will paint everything to be a common color once constructed. There is, in the River District, a 30-foot maximum height, and we're requesting a variance to that also. In this instance, the warehouse facility does not exceed 30 feet. The repair facility has requirements for very substantial cranes. The electric motors that are repaired are large and very heavy, and there are size constraints here that require certain sizes. The ridge line on the existing repair facility is 34 feet. The ridge line here is proposed to be 32 feet, 2 feet higher than the existing regulation. We're requesting a variance to that. We're requesting a variance to off-site or on-site parking. At the present time, there's an excess number of parking spaces. In this particular business, there are any number of sales representatives of the company that are seldom at the site. They're out making sales across this region of the country. So they're seldom there. In addition, service reps have vehicles that they take home and go from home on their service calls around the region, and so they are not utilizing spaces. Regardless here, the way that this is proposed to be constructed is that there'll be 87 spaces. The requirement is 104 spaces, so we're 17 short. There will not be the need at the present for additional employees, so we're not complicating parking from that standpoint. We're simply trying to find room to operate within. There is a requirement of a 30-foot maximum front yard setback. You'll notice that Western Avenue is the front yard, and there's already a series of buildings along that boundary. We're just physically not able to cram these things within 30 feet, nor is that desirable. The proposal here tucks these these buildings away, and so I think it's very appropriate for a variance as to the front yard setback. The final variance has to do with landscaping and screening. The way the Design River District Code as to landscaping and screening is set up, that it would like to emphasize landscaping along the frontage. That is all paved and constructed now. We are proposing and have worked with planning staff about this, of installing this entire row of 49 trees here. As I mentioned earlier, we are willing and will approach Oklahoma City about installing trees along the northern boundary, and we will approach Chesapeake about installing trees along the southern boundary, but we will not be able to proceed unless they're in agreement, of course. There are, of course, the four statutory criteria that you all are trying to apply to this particular issue. The first one has to do, does the application of the ordinance to this property create an unnecessary hardship? In this instance, but for the overlay of the scenic river, all these things that we're trying to do would be allowed by right. Evans operates in a very vibrant, competitive business environment, and nothing remains static. Changes occur constantly. This will allow Evans to respond to current market requirements. Evans management tells me that this should allow them to proceed without further additions for at least a decade. Now, there is a phase 2 that, if these variances are granted, probably within the next year or so, that we'll be back to one of the committees seeking approval of Evans would like to replace its existing offices that front on Western. What they are wanting to do is essentially this, is to move the office back, have a brick front construction on it with architectural metal roof, and this will allow more extensive landscaping. Similarly, at the time, they'll put facade on the existing western front of the buildings that now face Western to match the brick or stone type of the office, and try to maximize the appearance from that standpoint, but that's not today. That's somewhere in the future to try to improve the site also. The second criteria that we're looking at is whether the conditions are peculiar to this particular piece of property. As we said before, but for the overlay, all these things would be allowed by right. There's nothing that is inappropriate for an industrial site. The third criteria is that relief, if granted, would not cause substantial detriment to the public good or impair the purposes and intent of the ordinance. Now, all the proposed improvements are to be tucked away within the existing facility. We have an existing facility. It's not going away. It's been here for over 50 years. Whether the existence of an industrial facility inhibits the growth of the area is not changed by this request. The facilities are there. If it's really true that it inhibits the growth of residential or office or other commercial opportunities, nothing's changing. It is there. These particular buildings do not create additional problems. They're tucked away. They're very little change to the appearance of anything. The fourth and final criteria is that the variance, if granted, would be the minimum necessary to alleviate the unnecessary hardship. Evans is very conscious of its responsibility to Oklahoma City to not impact negatively the riverfront area. The way this is designed is to minimize or eliminate any additional impact by tucking these buildings away. We do believe that having Evans remain as a vibrant, thriving business in Oklahoma City is a considerable public good. And we have over 90 employees who, on average, have been here for 16 years. They also rely heavily on this business continuing to be successful. Nothing remains static. We believe that these proposed variance requests are appropriate. Happy to answer any questions you may have.
Questions from the board? Mr. Humphreys?
I got a couple of
You got
questions.
questions?
I do have a couple of questions. If I understand this correctly, we have 1, 2, 3, 4, 5, 6 ordinances that are coming into play, correct? And those pertain to landscaping, parking, metal siding, and under 59-15-200, non-conforming uses of buildings, which the statute specifically says at subparagraph C, no conforming use, except when required by law, shall be enlarged, extended, or reconstructed unless such change is to a use permitted in the district. Is that, yes, sir. Is that right?
It absolutely is.
And then what I don't understand is, I think I understand it, but I want to make sure I correctly understand it. The Riverfront Design Committee, in a 7-0 vote, said that we want to deny this request for a variance because it is inconsistent with the ordinances and it would set a bad precedent. Did I say that correctly?
I think in general that is correct.
Okay. Can you explain to us what they said about why the variance was inconsistent with the ordinances and why it would set such a bad precedent?
All right. As I made a very similar presentation to them as I have to you today, one committee member spoke up about how it didn't appear that the additional metal buildings impacted the larger site at all. Next, however, one of the committee members spoke up and went into his thoughts about that he had sworn and taken an oath to not do anything contrary to the ordinance and could not and would not be supportive of anything altering that, and made a motion and a vote was taken. I think if you all will read the transcript of the hearing, that it'll become very apparent that there was minimal to no, except for the one thing that I mentioned, discussion about the purpose that the committee's there for, which is to discuss design parameters. So it's my belief that it's appropriate, and the whole system is set up for an appeal process for us to appeal to you and have their decision reviewed. You get to do that de novo by regulation. That's what the system is, and so we view it as very appropriate to request you look at it for yourselves and satisfy yourselves as to whether criteria is being met. Another alternative that was available to us is we could have done a zoning change and gone through Planning Commission and City Council. We considered that very heavily. Staff was encouraging us, though, to think in terms of that variances for these defined changes within this footprint would be the least disruptive and cause the least impact and the least precedent-setting changes. And so we agreed and still believe that that was the good advice, and that's why we're here before you today.
When the riverfront ordinance was designed, put together, was there a provision in it for existing properties? And that may have to be answered by the...
It was, but they're considered non-conforming uses. So they're allowed to continue as they are.
Okay, but is there, in that ordinance, does it say that you can't alter that property at all?
15200.2 specifically says, no non-conforming use, except when required by law, shall be enlarged, extended, reconstructed, unless such a change is to a use permitted in the district. And I think that that's what the committee, one of the things the committee was looking at.
I think that's accurate. I might give a little insight. The ordinance was passed in 2007. In 2007, I was hired by W.W. Steele because you've got to remember this is a 5-mile-long ordinance. It goes from Meridian all the way to I-35, Reno down to Southeast 15th Street. And W.W. Steele came to me and said, "Whoa, we've got a big problem because we will have metal buildings in the future and we'll be expanding. Work with the staff." And you'll note in the ordinance, W.W. Steele was able to have specific provisions allowing them to do what our client is wanting to do now, and that was put in the ordinance. What has happened since then is not that the riverfront ordinance has been a shield to block any development, but that document I handed out to you all at the first, what has happened is...
Which is this one?
That's correct. And if you'll look on the second 2 pages, the first page, I took Evans' employees to the pre-meeting at the Planning Commission to make sure that they would be receptive to hearing our request, and was told they would. The second 2 are zoning cases that within the Meridian Business Park, with existing warehouses backing into the river, my client out of Dallas owned 3 lots, one of which had a warehouse on it, 2 of which were vacant. And the entire area was all industrial buildings. And so we went through the process. Ultimately, City Council approved the zoning allowing for warehouses to be constructed on the vacant parcels and reinstating industrial for the existing building. So that's probably why we wanted the continuance to start with, because we didn't want there to be any misunderstanding about what the design group did, but the history of what's gone on since 2007. And I don't think that ordinance was ever intended to say there'll be no changes. There are dozens of businesses along the river, not just Evans, not just WW Steel, but a number of businesses. And so generally, in the past, I've gone through the PUD process. In this case, the staff recommended to Paul that he go through the Board of Adjustment, and that's why we're here.
Did your client have the same opportunity to have the same objection that W&W Steel did and get the same kind of requirement?
I assume they did. They didn't have a lawyer. WW Steel hired me. I don't think they had any idea what the riverfront ordinance provided. And you want to come up here, Rusty? I mean, the problem is you got an ordinance that's passed. This is the perfect example. They have been in operation for over 50 years. They've seen good times and bad times, but they've been a great business for Oklahoma City. All of a sudden, in 2007, an ordinance is passed. I'll let Mr. Thrash speak for the company, but I don't think most businesses had any idea that if they wanted to do any changes to their operation, they would have to go through a rezoning process. But they shouldn't be punished just because they didn't have the foresight and knowledge to know that this would have an impact on them like WW Steel did.
Well, ignorance is no excuse, but we looked at it, talked about it internally, didn't think it would affect us ever. This is one location of 11 for us, and what would develop on the river was not a huge concern of us. I sat in this room when Mayor Ladding introduced the String of Pearls program, golly, this is a long time ago, and that, well, I think we had one equestrian pearl at Portland that went somewhere. So having lived through that time, this change as it was presented then didn't seem to be a big deal to us. It was not a major concern.
In this drawing here, is this all your property?
Yes, sir, it is. Yes, sir, it is.
And the building that exists on the north has been there for how long?
We built that building in '78.
Okay. And then the building that you're proposing to build the new building to the east, how long has that building been there?
The initial building was in '78. We built onto that building about 2001 or 2002, and then the new warehouse is a new warehouse. It's not tied to anything. So we've added on the initial building in '78, built on again in about 2002, and then we would like to build on that building again.
Okay, I've got another question to staff. If the unfavorable conditions, if they were met, if they agreed to do all the things that you're asking them to do, would that make this in compliance with the ordinance?
No. I don't see how you get past 15200.2 unless there's a change in the law.
Yeah.
If I may, Mr. Stonesider, and I think council could clarify this for us, but the ordinance is subject to revision or variance by this body. That is the whole structure of our system, is that there's a very broad ordinance in place, and this body is constituted to look at particular pieces of property, and where appropriate, to make or approve variances to allow a whole variety of circumstances to be dealt with. So I think it is inaccurate to say, well, the ordinance prohibits this. We have a very broad structure here that allows for this body to make revisions.
But it's not only one ordinance you're trying to vary, it's 6 of them.
And yes, but I think it's very understandable that given the site and the particulars here, that in fitting and tucking these in to have the least impact possible, it's causing some dislocation, so to speak. And yes, but so what if we can't meet the 30-foot maximum setback on the front yard? There's already a row of buildings there. I mean, it's just common sense that we can't do it. And so I think it's inappropriate to say, well, we can't change that. That's specifically why this board is constituted, to recognize that that's not possible. It's not feasible. It makes no sense. Similarly with landscaping, the planning staff recommended approval of this to the Design Review Committee. Now, they had a different opinion, but that's fine. But staff has been satisfied that the way that we're tucking buildings in, adding landscaping on the east side, they think it makes sense and are encouraging us to come through this process. So I think it's incorrect to conclude that, just like the Design Review Committee seemed to conclude, is, well, we can't do anything because the ordinance says we can't. Well, that is not true. That's not accurate. That's what this body is for. That's your job.
I guess I applaud Evans and their growth and their hiring of people in the city and everything they do. But the adverse impact on the riverfront, when this body tells me that it's going to be inconsistent with the ordinances and would set a bad precedent, that gives me great pause. And the reason it does is not just because of Evans, but it's when the next company comes up and they ask for the same thing, and then the next one, and then the next one. And we end up, I'm real proud of our city, and I'm proud of what we've accomplished, and I want some uniformity.
Yes.
And it looks like this board believes that this is a bad thing. And so all I'm saying is, this board has worked real hard to help business in the city. We're pro-business, and we want people to provide new jobs to the residents of Oklahoma City. But when this entity, this committee tells me it's bad precedent, that gives me great pause.
And I would submit in response that just like our example to the west, Mr. Humphrey's property, staff strongly recommended against it. All sorts of reasons of why it was detrimental to the district. But Planning Commission and City Council deemed it appropriate to approve it. That's fine. We want him to be successful. But just because some people on a design review committee thinks the ordinance cannot be challenged and changed, that's fine. We're not second-guessing their conclusion, but we have a process for amendment or for appeals to this body, and the structure is to be heard
for a variance. I agree with you on that.
To be heard over again.
And I didn't mean to interrupt. I apologize. Dan, in your opinion, is this, do you agree with him? Is this an appeal, and are we hearing this de novo?
No, this is not the appeal.
I didn't think so.
This is the question for variances only.
Yeah, and then if we deny the variance, they are granted the right to go to the district court and present whatever evidence they want.
That's correct.
Correct? To a judge and
That's
hear
correct.
all the evidence. They can hear the evidence of the committee, they can hear the evidence of the staff, and they can hear the evidence of this gentleman, correct?
That's correct.
Okay. You want to?
Any other questions? You guys
I'd
going
like to hear from Mr. Humphrey. I've got a...
Without any more questions, we'll hear from Mr. Humphreys.
Thank you, Mr. Chairman. I do agree with Mr. Lefebvre on one thing. Our ordinance is set up to, it's an overlay. And the reason the council put an overlay in place is it says, you know, the nature of this part of our town is going to change. And so we're going to put this overlay in place. We know what it is now. Here's what we'd like for it to be in the future. And in a broad overlay district, there are places like WW Steel where it's entirely appropriate for them to come in, expand their use, because that didn't threaten the intent of the overlay. I believe this does. Let me read the specific wording in the ordinance. By the way, this was first envisioned in 2002. I used to know the mayor at that time. And Studio Architecture was hired to look at designing a design overlay. And they reported back in 2004, and the council adopted it in 2007. So this was not done in a closet. It didn't come out all of a sudden. It was done in a long, open, broad public process over a period of 5 years, and was enacted 6 years ago. So they've had 11 years' notice thus far. Here's what the ordinance says. For the Western Gateway, it says, the intent is to establish the downtown Air Park site in adjacent parcels as a vibrant, mixed-use neighborhood that incorporates a variety of housing types and supporting uses as opportunity for a transition in use arise. The second intent was to enhance existing neighborhoods within the district by encouraging investment and targeted infill and redevelopment. So the river's changed. I mean, you know, Larry Nichols, when Devin supported the boats on the river, he told his dad, John Nichols, who was in his declining years at the time, he said, Dad, we're going to sponsor these boats on the river. And John Nichols said, what river? There's no water in that river. Well, it's changed. And the city has invested really well over $100 million by the time we get done with MAPS 3. Well over $100 million. We have water in the river. We have people using the river every day. We have recreational uses. We have rowers. We have all kinds of investment. And we'd like to have housing down there. Change takes time. Bricktown started in 1989. And there have been industrial uses in Bricktown. The Stewart Metal Works has been in Bricktown until a couple of months ago when a partnership we're a member of bought it, tore it down, and we're building apartments and a hotel on it. That's the way change takes place. It takes a long time. Bricktown's 24 years old. And I would tell you, Bricktown's an adolescent. It's still not mature. It's still transitioning. But it's been protected by a design district that says, yes, you can do this, and no, you can't do that. And so the industrial uses and the pre-existing uses have been allowed to remain, but not to expand. And therefore, now you're seeing housing moving into Bricktown. So now we have water in the river, and we hope to have housing on the river. In 2006, the city approved the Core Shore Plan. That's 7 years ago. To my knowledge, not a single new building has broken ground in Core Shore. That's how long we've owned downtown Air Park, 7 years. And so change takes a long time, but if Bricktown is an adolescent, then the Western Gateway and Core Shore are prenatal. They've not been born yet. They've not taken the first steps yet. And because of that, they need protection. They need care, they need nurturing, and they need protection. And that's really why the Design Overlay Committee and why this board, the council, put these in place. So you can look at the facts. You can say, you know what? With WW Steel, that makes sense. It's not going to encroach on any use that we want to encourage. But in this case, it's different. In several ways. They've talked about the concert venue across the street on downtown Air Park. I'll give you the facts on that. The application was for a 3-year limited permit. Our lease with the operator, and I gave the lease to the Planning Commission, is a 9-month lease. It expired. The first concert will be later this month. and their lease expires at the end of November. And they have an exclusive right to rent the air park from us the next 2 years if we choose to not move forward with development. But that's our choice. And I talked to Howard Pollack yesterday. He said, "How are you thinking about that?" And I said, "Howard, I'm planning on moving forward." So that lease will expire November 30th. We asked for a temporary permit for a 9-month period. Evans is asking for a permanent use. They've already had 11 years' notice, and they've said that this will take them for another 10 years after their next expansion. I would not buy a home next to a metal industrial building, nor would you. And the city knows we wouldn't do that, and that's why they put the overlay in place, so that those uses in time move out. As their land becomes more valuable, quite frankly, I'm excited they've grown. But as they grow, they need to find a site and a facility that's appropriate for that use. When they talked about landscape, they said, well, we'd be willing to talk to the city about putting landscape in place on the north and to Chesapeake about putting landscape in place on the south. If I'm correct, Mr. Fleaver, that'd be off of your site in both cases. So they're hoping to convince you that they're going to meet the intent of the landscape ordinance on someone else's land. Why? Because they're having to shoehorn this thing in there when they don't have enough land for it. And that's why the ordinance is in place. So I have no problem with their setback on Western. I think that's fine. I have a huge problem with metal buildings. If I'm trying to get people to move in to townhouses, to owner-occupied flats, to apartments, to retail, I have a huge problem with expanding the use of metal buildings. I have a huge problem. When Mr. Lefebvre talks about sight lines, he acts like there's no one south of the river. He talks about visibility from the north, and they're tucking it away. They're not tucking anything from the south. Nothing is blocked from the south. And yet, if I go down to 15th and Western and put my first phase in there, they will be in my sight line between my development and the Devon Tower, and it'll be higher than it was, and it'll be bigger than it was, and it'll be a metal building. So if you want to kill any hope of new development in Court Shore and in the Western Gateway, approve this variance. But I would ask you to deny it. Thank you. I'd be happy to entertain any questions.
Mr. Humphrey, short of moving, getting out and finding another location, what do you think would be acceptable to you for this expansion?
Well, if they want to operate in 2 sites, I mean, I've done that in my company before. They can do that. But other than that, I would ask them to comply with the ordinance, and that would mean masonry structures. That would mean not above the height. And that would mean comply with the parking and landscape requirements on their land. Other than that, to me, it's a form-based thing. It's not a use thing. I have no problem with an industrial use in that site. I have a problem with it's disingenuous when Mr. Lefebvre says they're doing everything they can possibly do. This is a company whose business has grown 60% in the last year. They're saying they can't afford masonry, they can't afford landscape, they can't afford to move to a site that's appropriate for their use. So, but I'd say if they want to do it and if they want to comply with the ordinance with masonry, I'd be happy if they can comply with the rest of it.
So are you saying you would be happy with masonry on the new construction, or you want masonry on the whole?
I'd have to see what the ordinance says. I believe it says that if they, I can't remember. I'd defer to the counselor, Mark Stonecipher, who's read it. Do they have to comply with all of it, Dan, or just with the new construction? I think the whole site has to come into compliance. That's the nature of this area is changing. There was a time in Bricktown when no one went there other than vagrants who wanted to light a warehouse on fire. That's not today. And that won't be the Western Gateway in 10 years either. Thank you.
Thank you. You may.
these metal buildings are there today. If it's true that no one will choose to utilize the area because of metal buildings, then it's not going to be used because they're there now. They've been there for 50 years, and they're going to continue to be there. So if that really is the determinative factor here, then the fate is already sealed. This area is not going to develop. I personally don't believe that. And I think that there can be compatible mixed uses that allow the area to prosper. And it's hard for me to understand why anyone would make an investment in this property if they truly believed that if those metal buildings stay there, it kills me. Those metal buildings are there. They're going to be there. They're not changing. The issue here is, do we want to allow a thriving Oklahoma City business to continue to meet marketplace demands and thrive and allow them to do what they're legally allowed to do, or do we want to choke off their growth? Is that helpful to the city? I would say not.
I think nobody on this board is saying that we're not pro-business. Nobody on this board is saying that we're not pro-small business. What we are saying, though, that what you proposed does not meet the zoning requirements, and we're having some problem allowing you to deviate for that.
And I do understand that.
And that's what the issue is. This board is very pro-business, in my opinion, and very pro-city. The conditions from what your business has, over the 50-plus years of your business being in existence, the surrounding areas have changed, and you're being affected by that. That's what this board's trying to reconcile.
Sir?
So thank you. I just wanted to be sure that you understood that nobody on this board is not pro-business.
Thank you.
Mr. Reynolds, do you have something to say? Yes. Cool.
Thank you. I don't think anybody's saying the board's not pro-business. It's just certain selective types of businesses, apparently. There's a pattern here. As I said, I became familiar with the Flatiron property a number of years ago, which got a TIF. And the Flatiron property had a deed restriction. It said alcohol could not be served on that property. It was given by a major general before statehood. And it had a deed restriction. If that property could never have alcohol served on it. And I was stunned to see that the city of Oklahoma City found a way to file an eminent domain against itself to remove that deed restriction. Now that was done at the behest of Mr. Humphreys. So it's all right to find a way to bend the rules, apparently, when it benefits certain businesses. Other times it's not.
That does not have anything to do with this hearing today.
I believe it does.
You just quoted. No, Mr. Humphreys is in here in a different capacity. There's nothing before those facts and circumstances that is before this hearing. We are a quasi-judicial tribunal, and we do stand independent and impartial. And I'm not going to allow you to downdress the committee. That's inappropriate. Sir, if you have a comment about what's going on with the situation, I'd be more than happy to address it.
Thank you. I noticed earlier today a number of my constituents were here for a variance. Their homes were wiped out in the tornadoes, and the board granted a variance for them to live in, I guess, motorhomes or something while their houses are being rebuilt. I would expect that in a strict reading of the statutes that we've read today, this board shouldn't have approved that. Would that be true?
Those were all temporary, that were related to a nuance in the code between a mobile home, which can sit on the parcel of land for an indefinite period of time, and a trailer, which there were some time restrictions. Is that correct?
Also, Mr. Chairman, we are entitled to do that under our statutory standards.
Absolutely.
Well, I would be very disappointed to see this variance denied. I believe it would impact the economy that we so desperately would like to see in Oklahoma City improve, impact sales taxes directly, and I certainly would agree that I would never buy a property and build a house across the street from a metal building, but if someone chose to buy that property across from a metal building, then that's probably what they expected to be there.
Thank you. Any other questions from the board? There being none, I'll entertain a motion.
I will move to deny the variances.
So that, is that one or all of them?
All of them. That was plural. Sorry.
Second. Is there a second?
I'll second it so we can vote.
I got a couple of comments before. I'm having a hard time trying to determine how a building built in the middle of a piece of property that has not been able to see from the road or from the side yards, how does that impact the property? I understand the building on the south, and I understand what Mr. Humphrey is saying about the building impacting his property. And that's the only property that really would impact Mr. Humphrey's property. I'm just having a hard time trying to see the impact, and I don't like metal buildings particularly either. But maybe there could be some kind of compromise on the new metal building and the old metal building on the south. They pretty much agreed to do the landscaping, and the only thing that would be outstanding then would be the 17 parking spots.
The issue with the landscaping is, though, they don't have the land to do it, correct?
They what?
They don't have the land to do the landscaping. It's owned by Chesapeake.
On the south, they don't. Yeah, but the rest of it they do.
Okay.
Yeah. They do on the north and they do on the east.
On the north.
Okay, so the drawing that I'm looking at is not really correct then, is it?
The only thing they have control over where they're proposing to screen is on the east. They would have to get permission from the budding property owners, the city to the north, and I presume Chesapeake to the south to do any landscaping. But they would all be off-site.
So their building is right up against the north property line?
Uh-huh.
But it doesn't show that on the drawing.
Mr. Allen, if I could offer an explanation on the impact of the buildings to the property in the south and west. As I understand it, Mr. Lefebvre, I'm going to reference this building and this building. My understanding is these two buildings in the blue hash mark are new.
Yes.
And they're 32 foot tall. And so as you move to the south and west, those do dramatically impact your views toward downtown.
I understand that.
And so the height of the building is an issue, and the ordinance puts a specific limitation on industrial uses because they're typically big uses that are like a screen across the landscape, and it would impact the sightlines toward downtown.
Put that back up there if you would. See, is that the property line to the very north? So what's the width of that property line?
There's not much there.
What's the width of it?
10 feet.
And that's not enough room to plant
All
a
right,
tree?
it's enough room for us to plant trees.
Is that not enough room for us to plant a tree? This area right here.
Right here?
Yeah.
Narrows down, then it turns to concrete here, so you get trees.
Take the concrete up. If they want to agree to that. I'm just having a hard time seeing where this is an impact. I mean, the building, the metal building is already there. And you can see the metal building now, and you're going to be able to see the metal building apparently for another 50 years.
Here's the point. As uses change, and the ordinance contemplates this. Let me see that. The ordinance grandfathers existing uses. The buildings have been there 59 years, they'll be there, okay? But it says that as opportunities for a transition in use arise, they want to encourage residential and mixed uses. So what happens over time, when people like Evans grow, they move to someplace else where that can accommodate their needs within the code. Someone buys this, and they either are changed to a conforming use, or they're bulldozed and you rebuild something on the land. So to say that they're going to be there forever in their current use, go look at Bricktown. It doesn't happen that way. Stewart Metalworks, we tore the buildings down, and you'll see apartments break ground on that in the next few months. That's the normal. When you have an overlay district in a part town where the use changes, that's what happens. If this board allows Evans to double up on their investment, then you're really encouraging that use to stay for a long, long time, and that's where it would negatively impact the surrounding uses. I'm not disputing the existence of the existing buildings, and they have every right to stay there as long, whether it's Evans or someone else, as long as they don't expand the use. They have every right to stay there under the ordinance. It's when they start expanding the use that they have to come into compliance.
Any other questions?
One other comment. If the south elevation is the heartburn, we can do some brickwork. We can do some things on that south side to improve that elevation. Metal buildings are metal buildings. They're there now. They're going to be there. If the south side is the problem, we'll work out something with them. We can't brick 30 foot tall. We can sure put up 6 or 8 foot of wainscoting type brick down that south side and across the fronts of those buildings. We plan to do the fronts anyway.
Is any of that acceptable to you, Mr. Humphreys? Okay.
My concern on this is we got to hit all 4 of the statutory elements on each one of these.
It's land.
And
it's a tall hurdle.
It's hurdle. Yeah.
We have a motion and a second to deny all 6 variances. Any further comment? Let's vote. The variances are denied. Thank you for being here today. The next case.
Item number 12, case number 13758, request of Crossings Community Church for a variance to the required number of parking spaces located at 14600 North Portland Avenue.
Sorry, I need to clean house here real quick. Brian Kuhn with you, as always, representing the applicant. This case was before you in a certain way, in a small way, probably 6 to 9 months ago. The church and school are building a football stadium and a baseball field on this property, and it's kind of off that map.
Just one second. Okay. Do you still represent Epworth Villa?
Yes.
I have a conflict as chairman of Epworth Villa and need to step out.
Take over. You want me to? You want him to? You want to? Okay, now keep going.
I forgot he's on the board at Epworth, and I forgot we represent them too. So anyway, but I do represent the school and the church, and I will just put this up here just so you can see it better. Portland Avenue, Northwest 150th on the north. This used to be Dobson Communication. right here. Now it's now AT&T. Just to familiarize yourself with where you are. Memorial Road's right down here. We bought this property, probably a year ago. We're building a football stadium here, as well as a baseball stadium here. There'll be a field house. Really, it's more locker rooms than field house. The new high school building is here. Elementary school building is here. We are currently working on the construction plans for the middle school here. We were before you, maybe it's a year ago at this point, for a special use permit for the athletic fields here. We have agreed and dealt with the owners of the AT&T building of certain frontage and for certain fencing and certain facades we're going to put on. We're fine with all those. And there was also a minimum number of parking spaces that were included in that agreement. So we're still meeting all those. What we've come against now is, and I learned something almost every project, is what we've come against now is that parking has to stay only on your parcel for where your building permit is applied for. That is this piece here. When the full build-out of this happens, the requirement would be that we'd have to have over 300 parking spaces. If that's the case, we couldn't build a football stadium or probably the baseball field. What we have is we have over 1,000 spaces here that are owned by the church who owns the school. So our request before you today is just a variance to the parking requirement. We're still going to meet the requirements of the AT&T agreement. I think we have a little over 80, maybe it's 88 spaces on the site. But if there's a football event here or track, we have sidewalks. This will be the new common building with a field house for the high school. There'll be sidewalks through here. There was plenty of parking on this site that we'll have all the access to. So I can go through the 4 statutory standards if you want me to. If not, I'll shut up.
All you're saying is if we get there late, we may have to walk a little farther.
You're going to have to walk a little further.
That would be the only thing that I see is I understand, what you want to do is just some people are going to be parking some distance away and they're going to have to traverse, but I have no objection to the variance request and would make a motion to approve.
Do we have any?
Anybody here in opposition?
I don't believe they're with me, so
They're probably in
I think
favor.
we're good. I think they're for us.
Okay, did I hear a motion and a second? Okay, motion and a second. Go ahead and vote, please. I think you got it.
Thank you. Appreciate it.
No other items on the docket. I will entertain a motion to adjourn.
So moved.
Second.
All in favor? We are adjourned. Thank you.